goes in here, for your reference purposes. Carbon monoxide detector.
I'm sorry, I just had a quick question. Rosemary. It's on wording for the contract. I just want to be clear, we're going to get a new purchase offer in Dotloop with new wording that doesn't say.
It's a legal document.
It does say that
It will
already.
no longer say that.
It will no longer say that. Is there anything wrong when we have a client who's a seller who's desperate to sell, wants a signed agreement, and we're, wanting to follow Article 9 saying we want to get all agreements in writing, that we say in that purchase offer that's not a legal contract, it's subject to a more formal contract of sale being signed. It already has subject to everything else.
That's the language that I was reading. It's all going to be included in that.
And the question is still having the seller sign it.
Listen, as long as the language is in there, and the parties understand that that's not a contractually binding document, it doesn't matter what type of language I come up with, yes, it's fine.
How does that to the claim for broker's commission based upon the meaning of the deed, based upon that document?
Right,
signed?
right.
So,
Your broker's commission, right, you got it. That's
why it's our recommendation from before the Ed to not have a seller sign.
right.
Unless our client, the seller, insists that there's something to get them to the next stage. I also have a problem with as a buyer's agent, I can say to another broker, your form, my seller cannot sign that form. And here's the reason why, and they may want something else in writing, because when I'm a buyer's agent, and I, beat a path to a property that's very hot, and I get my buyer in there, get an agreement on the table, the seller agrees to it, and there's 5 more showings the next day, I'm gonna tell them, the attorney doesn't want to draw contract until you have an inspection, the inspection's 5 months as well. You don't have anything in writing saying that you're not number 6.
Let me just ask you a question. What's to stop the seller from taking another offer, even if your seller signs it, even if your buyer signs it? So, what's to stop them? If it says that this is not a legally binding contract?
I guess it's just having agreements in writing that maybe even if it spells out.
The agreement in writing really, for purposes of trying to establish, it's pretty simple. There's a lot of case law, and it's not simple, but there's a lot of case law that, if you bring a ready, willing, and able purchaser, unless the listing agreement says if, as, and when, and you have certain language in there, that type of stuff. There's really there's no way, you can bind the seller to anything. So, in reality, the custom is no one's going to really go after the commission if the seller pulls out and really accepts another, for the most part. You're not going to, it's just going to be another deal. You're not going to kill relationships. This is really just in practice. If a commission, if you bring ready, willing, and able purchaser or seller to the table, and there's tons of case law that goes one way or the other, having a written agreement, you have to really explain to the other side, or to your client, there is nothing I can do. I tell all my clients, and listen, it's not a great, it's not something that I like telling them, but I tell all my buyers, until I send the contract to the seller, and the seller signs it and emails it or mails it back to me, you're not in contract, period. They're like, what do you mean? And I just repeat it. And then they say, but what do you mean? And I just say it a third time. And by then, you're probably okay, because really, I do it all the time. I send out a contract, down payment, and then I get a mail back. And you try to find out what's going on. The seller's attorney doesn't call you. You don't know what the status is. And then you get a mail, an email, a package back with a check saying, thank you, but we want to do another offer. So, that's the kind of stuff that you probably, and most of the cases say, yes, New York is still a very willing and able state, but they're still going to take into account, what stage you're at. So if you have written agreements and it's conditioned on, inspection and a mortgage and all of that, it's still conditioned. So, you know, putting the language in there and they sign it, fine, they sign it. You know, it's not binding to them. It's probably not going to establish a ready, willing, and able standard in the court. So, you know, you're going through a process where you maybe just, you know, I mean, not shit this way. You know, going through a process where it may be just easier to set the, you know, guidelines, set it up front, and so that they're not under a misconception of how the deal really works. You have to say, listen, I've done real estate for 20 years. You know, we're going to submit an offer. They accepted the offer, and tomorrow if they call me and say they don't. I mean, that's what, you know, most people know that. You know, if you're straight up with them and you clearly define that up front, they're not going to come back and say, you misrepresented me. But if you don't say it, they're going to come back and say, you didn't tell me that after I, you know, went. And even to me, you know, I don't have that conversation with them. They're going to come back to me 2 seconds later when I call them and say, listen, I got the contract back and they rejected your offer. If I didn't have that conversation with them 3 times, right, they would be picked off at me. Just in the same way that they would be at you if you don't really clarify what the process is and how it works. And you have to, you know, this goes into another course and we have a lot of material. So like I said, I'm going to hold questions to the end of each section, but just a quick point. You have to let them know, if you do an inspection, you're going to lose that money. You know, have it in writing. I have a DOS complaint that I worked on where they're alleging we want the money for the inspection from the broker, because the broker never told the client that, you know, the buyer never was told. So have it in writing. You know, have it say, please note, there's a disclaimer, you know, I can certainly help out. You can have certain disclaimers on the offer that says, if there's an inspection that needs to be done and the seller withdraws the offer prior to the contract signing, please note that you'll be responsible. So you don't have to worry about all this stuff. If you tell them what happens, they know they're going to put out $350 for an inspection and lose it. You know, if they say, I'm not putting out $350 for an inspection, then they say, then you're not going to do a deal, because every deal now, no attorney's going to allow a 10-day or 15-day inspection, you know, contingency period like we used to do even 8, 9 years ago. You know, that's when it starts tailing off. But let me start going to the next section. Carbon monoxide, this is just an update in the law. I know most of you here do residential. For the few that do commercial, just note that there's just a distinction between new commercial, existing commercial. We require all CO detectors to be in commercial buildings and restaurants. That's basically the rule. If it's 2015 to the end of, if a building is existing or you have actual building permits pulled, okay, you're considered a pre-existing commercial building. If anything new, say you're in zoning board approval, you didn't pull building permits are pulled next month or next week, and we're in 2016 now, it's going to be considered a new commercial building. The only difference is, existing, you can use a battery powered, it has to be UL listed, okay, I think I have the code there, UL 2034, it's a 10-year battery life. You can use that for all 3 existing buildings. It can't be a dual detector like we have in residential. There's a smoke alarm on the property, it has to be a separate carbon monoxide. For all new commercial buildings, it needs to be hardwired, which means it needs to be tied into the central tank, okay? And that's basically the carbon monoxide law, you know, in a nutshell. There's really not much. I've added, you know, sections of the law if you want to take a look at it. There's a couple of exemptions for canopies and some other small, you know, exemptions in the bill, but other than that, we're pretty much, you know, set on that.
I have a question.
The definition, hold on, I believe it's I'll look it up, it's just so we can move forward, but it's in the, there's an exact, definition of it, and I'll tell you, you know, at the end.
I have a question. Now that we have this information, what are we supposed to do about it? If you know that an owner doesn't have it, I
You
mean,
have to make sure that the owner's compliant. So,
but there's no form they have to sign or anything?
no, there's no form, it's just a matter of you knowing that this is an issue, and that it'll come up, so if he sells, and if not, it's gonna delay the closing.
Okay.
So as far as the realtor community is involved, you know, is concerned, you basically just have to make sure the seller's compliant with the new law. I can guarantee you, 80–90% of the commercial builders and the commercial owners don't even know that this law existed. The update on Neighbor City, basically this was a lawsuit that was involved. It's been, you know, long-standing lawsuit. You know, we can go through it. I just want to, you know, basically touch upon that it was decided by, it was basically came down in early this year that they granted the National Association of Realtors summary judgment motion on this. The Hudson Gateway Association was also part of this lawsuit. It involved the scraping of copyright.
Yeah, so this was a company that was out there, and actually we did have agents within our market center that were contacted by them. They would offer you a referral fee, because they would put out a website, but basically what they were doing was scraping data from the MLS, and that was how they were generating referrals to agents. The bottom line to this, and the important part about it, is that the agents had come to me, and I was aware of this, that there was a lawsuit going on, so we did not enter into any of these type of referral agreements. So the bottom line is, if you have a referral agreement that you want to enter in with somebody, you need to come to us first, so that I can look at it before we sign on to it. Because, you know, there could be culpability with us through the MLS, if we give out the data and allow the data to go to these types of third parties. So we want to know where our data is going.
And, you know, this is just a copyright, you know, infringement case, and basically just establishes that the copyright is still alive and kicking. Neighbor City basically was saying that it's, you know, the fair use doctrine, it's out there, it's not. If there's photos, if there's copyrighted material, you can't just use, you can't scrape it. And Rosemary points out that if there's any agreement or anybody contacts you, please, it goes through compliance, it goes through Rosemary. You gotta make sure you don't sign anything, because obviously you may be giving rights away to something that you don't even have rights to do. So that's the major takeaway. But we've been reporting on that for years on that case. Finally, it's been settled and in our favor. The next area basically is the mold remediation specialist. This is a very key area that you should be aware of. I'm going to point out quickly what you need to know. From a realtor perspective, you got to make sure, you know, there's going to be a mold remediation company taking, you know, if there's mold issues at the house of the subject property, there are now two requirements, two different entities or people that you're going to need to engage. The law says that if you're going to have a mold assessment company do it, that person has to be separate and apart from a mold remediation company. So that's really the takeaway. You know, the fact that now they have to be licensed, there's, you know, licensing requirements for mold remediation specialists. You got to make sure from your standpoint that you ask for licensing if you're referring, you know, any mold companies to do this kind of stuff. And you have to know that now the sellers are going to be responsible if they do subject themselves to paying, you know, whatever any mold issues are. You're going to have to pay an assessment company to prepare a report to say what the issues are. Then they're going to have to pay a separate company to do the remediation. If there's a conflict there that the state basically saw that they, you know, that they needed to clarify, make sure that you didn't have the same company doing it because there was just a conflict, an inherent conflict. And again, there's copies of the actual bill attached or provided. Truth in lending. This is the new TRID rules. I'm going to go quickly through this, but really, I can't even tell you. I do, you know, 250, 300 bank closings a year, okay? Representing just the bank. I've done 2, okay? since October 3rd, because most of them all were prior to October 3rd, I have about 15 or 16 pending new trade applications that I'm doing, and we've only closed 2. The 2 that I've closed, 2 diametrically opposed, okay? One, the bank said you have to have the bottom number match, all the checks have to match. If it doesn't, we're not closing. We have to redisclose. There's a 3-day business day redisclosure rule. Another bank, the bottom line didn't match the checks. We asked them, we emailed them, they said, don't worry about it, it's fine. You know what? I got it in an email, I'm covering myself, and that's all I can do. As far as the new ones, all I can tell you is you have to be upfront with your clients, okay? Quick, you gotta make sure you tell them, we don't know what trade's gonna involve. I don't know, and I can't tell you. I can tell you with certainty that a redisclosure has to happen if there's bank-related issues, fees that have increased, if the APR goes up in any way, okay? That can happen while you're at the closing, okay? Either a mortgage broker messed up, a fee wasn't disclosed. If something like that happens, you're actually going to be at the table, you're going to adjourn. I'm sorry. You can't say, let's redo the HUD, let's send it in. It's not a HUD anymore, it's a CD. It's even worse. It looks crazier than the HUD. I prefer the HUD. When that came in, I was like, ugh, I want to go back to the HUD. But anyway, the best I can tell you is you got to tell your clients there's no more stack closings. If they're buying and selling, please don't, and I'm with all, due honesty, don't tell them, yeah, we can try to figure out how you can close on the same day. It ain't happening. The problem is, even if you can figure it out and it does somehow coordinate, you now have to hope that one closing doesn't get adjourned and then the other one gets messed up because of it. I've been telling all my clients that I prepared a rider that goes to, that gets attached to my contract for sale that basically give everybody a 10-day cushion, okay, and basically say, this is, you gotta work with me. So if I'm a buyer, I attach my rider. In my rider, it says, you gotta work with us. I'm not gonna be held responsible for trip delays, adjournments and closing, changes. If I get a seller, agree to it, that's great. Most sellers' attorneys, and we go up to Albany, and we sit there in a legal conference, it's about 20 to 25 of us, and we just go around, and half of us, we're arguing with each other. We all handed out riders that we all prepared, and they all laughed, because they said nobody's gonna sign it. So far, every one of my sellers has signed it. Why? They don't even know. So, I'm good, for a little bit. So they figure out what trade actually means, and I would say January is going to be a big month. I can guarantee you there's going to be huge penalties to banks within the 3 months from October 3rd to now. Because I can guarantee you, just like the 2 or 3 that I've done, half of them are not going to be in compliance with the new rules.
And I would say, if we're representing the seller, we should probably be proactive with the seller's attorney in getting the document that they're gathering with all the information from the brokers and get that over to the buyer's broker, so that they can sign it and they have all that information well ahead of time.
Yeah,
so we have to be proactive on that.
Yeah, what I've been doing, Marie, is I've been telling brokers, and I just started literally in the last few, several weeks, 2 months, but telling them in their offer, okay, in their memos of sales, in their offer, you have to provide licensing, your license numbers, okay? Provide them for both the agent and the broker's number, okay? Most people say, why are we going to give this information? Nobody should know it. Well, it's required on the CD. If you don't give it, you're not closing. So we don't get an approval or a clear to close. So that's kind of the information. You got to make sure you have the correct address from the brokerage firm on the memos of sale or the offers. So that information is given to us ahead of time. As much as you can do to help us get that information on paper, so that when the bank, attorney calls me and says, John, we need the broker's ID number, we need this, we need that. I just give them the offer, the memo of sale, send it to them, and they have that information. I can tell you we've been We have to get closing costs and CDs approved at least 10 days, 7 to 10 days prior to any even potential closing date. We send it in, and then they approve it or disapprove it. That may go back 2 or 3 days. I think once the process is gotten used to and we get on, on the right track, we could probably close quickly, provided that there's none of these crazy, issues that come up. So that's my main point here for realtors. Whatever the attorneys ask you for, just give it to them. Don't, make a big deal about it, unless obviously it's not required as a CD, and then you speak to us and you see if it's information. Another big issue, and that I always try to just point out, everybody wants a copy of the HUD. That's what, just so you know, the DOS does not require the brokerage firm or the agent to get copies of HUD for closing. I was actually in the meeting with Whitney Clark, and she told us face to face, where the hell did you get that rule? It's nowhere in the DOS regs, but I can guarantee you 98% of the closings I do, every broker says, give me a HUD, give me a CD, give me this, give me that. The thing is if they don't give it to you, the law only requires that a memo be placed in the file of the significant terms of the deal and the closing date, which you can get basically from the contract of sale, the closing date, the purchase price, and that's basically all the law requires. So I've been getting, I've closed, some deals with the CD, and actually one attorney said we're not giving it to the broker, and the brokers were, I was with the bank, so I didn't get involved. But they said we're not giving it to them. Don't ask me why. I normally just give it to them. I ask my client first because it is a document that pertains to the transaction. So I ask my client, buyer or seller, is it okay to release the HUD, and I give it. So that's an easy way to do what regs require. You get the HUD, you put it in the file, and you don't have to do this extra memo. If they don't give it to you, it's not the end of the world. You're just doing an internal memo, just basically covering those items, and you'll be okay.
We have a form that we ask the attorney to sign if they're not going to give it.
That's it, So you'll be covered, but again, it's not required, you won't be held liable, but you do have to have a memo of the transaction, which is kind of the terminology that the DOS requires. So again, the 3-day business disclosure, you just got to be, and the only other thing that I would point out on the TRID is for new construction. A lot of the construction builders like to put dead dates, steadfast dates in the contract. So they don't like the on or about language, right? So they say you have to close on February 1st, that's it. If you don't, you get a penalty, for every day you close beyond that. The attorneys and also the sellers, the sellers' agents have to tell the new construction builders, listen, there's TRID. That there's TRID, and that they have to be a little bit more flexible. It's up to you really to try to convince them. I represent builders. I've already told them. They're already saying, yeah, whatever. I'm going to put it in the contract anyway, because if there's a TRID issue, we're all subject to it. It's not, it's not the buyer's fault. It's not the seller's fault. We're all subject to it, unless there's a real reason why it's not getting approved. And that's internal, and that has to be done, dealt with the attorneys. But sometimes it's the buyer's fault. They're not giving the documentation. One big issue, and I would suggest you tell your clients this so that in case their attorneys don't tell them, don't enter into leases or buy another house or do anything that affects your credit between the time you sign the contract and the time you close. I've had 5 deals get canceled. Banks withdrawn their commitments because they do an updated credit report. So probably, and I'm not kidding you, probably on a weekly to 5-weekly basis. The minute I've had one person entered into a lease 3 days prior to the closing for a car, the bank withdrew the commitment. Withdrew the commitment. The buyer is going to lose their down payment according to the contract. So just, it's a tidbit of information that I would say, this isn't a legal thing, but it's something more logistic that has to do with TRID, because TRID really, and the Dodd-Frank, regulations, it really changed the lending landscape. I had another guy who just told me the other day that he closed the TRID deal in 30 days, contract to close it. If we could do it, God bless, my experience has been probably 60, you thank God, 90 is probably the better window, 120, you're really out there. So if you're within the 120 and 60 day, don't keep calling the attorneys, don't keep calling the buyers, the sellers, and it is what it is. If we get that one deal that closes quick, thank God, but for the most part, I do a lot of these, so, it's unfortunate. But it looks like it's getting a little better as they learn how to do the TRID and get the CDs approved ahead of time. I'm going to just quickly go through teams. It really, the key thing that I tell you is they focus on advertising regs. The advertising regs really determine how teams, can function, and how we go ahead. There's legislation that's being presented that would actually define what a team is. Again, like I said, a team is defined in the statute, but it's not defined in the RPL. So they basically, the last 6 months has seen an explosion of teams, really, in the boroughs and Westchester and Long Island. Teams are all over the place. So you have to just know that you really, all the issues, really have to just, what I tell everybody, focus not on the team, but on the individual sales agent or broker or sales associate. If any reg applies to an individual, it applies to the team the same way. Okay, so if there's any issues, you basically use it as a guideline. There are some issues that I just want to point out to you. A team is not a separate entity. You shouldn't be forming an LLC, and making an entity known as the, John and Anna team, where the best, blah, 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 and it's John and Anna team LLC. And then you start hiring employees. That's a no-no. You can't have W-2s. You can't operate it as its own company. You're still subject to all the brokerage requirements that you're subject to as a sales associate or as a licensed, associate broker. Okay, so really the brokerage firm is what's at the top, and anything you do has to be in compliance with that. We've had companies that are actually, hire employees, paying W-2s, are W-2ing employees out of that thing, and it's really the law is specific. The LLC law that was enacted a few years ago is only for the purpose of collecting commissions under a limited liability entity for the person who's collecting that commission.
I just want to clarify on that because we've had extensive conversation and direction from Ed in the past. If a sales agent is hiring a non-licensed assistant, okay, they can pay that non-licensed assistant themselves. They determine whether it's W-2 or 1099 based on their conversations with their accountant. And it may be paid out of a limited liability company if that's how they're getting paid. However, anybody who is licensed and is working on the team has to be paid through the brokerage.
Through the brokerage, right. So, and again, that's just to clarify that it's exactly on point. If you have a reception, an assistant, an admin, you could actually, pay that expense out of the LLC. Other than that, everything else, any commissions or commission splits or any, payment of that has to be done through the brokerage.
And those admins cannot hold themselves out as working for Keller Williams Hudson Valley Realty.
No, absolutely.
They're unlicensed admins.
Right. And you have to be specific that they're unlicensed. If you have any ads, again, the ad guidelines, if you have any ads that include non-licensed personnel, you have to explain or specifically disclaim that they're not licensed personnel under, the brokerage firm or the LLC. Branch offices are problematic. This is a new development. As per the Department of State reg, the branch office is not permitted to require the team to pay for more expenses than it would an individual salesperson. So you have to just be careful. That's what the DOS is telling us as of November. They're saying that if you have a branch office and you're trying to have the team pay more than it's fair, more than it would have paid if it was just an individual associate or licensed salesperson, that they're looking at that as not as being disallowed under the regs. So just gotta be careful. Just look at your own internal procedures, and that obviously is on a case-by-case basis, and you have to make sure that we're in compliance. A lot of times they'll come down with interpretations of the law, and unfortunately, unless it goes to court, we can't tell them that they're wrong unless we can, smoke them gun and say, oh, by the way, the regs say that you're absolutely wrong. Teams do not exist and should not be included in the MLS data fields. Team leaders and brokers are open to liability. So you can't say in the MLS field that the teams, it's got to be the individual licensee and the brokerage firm. Teams are not under the view of the DOS. They're not a separate entity or a licensed entity. So again, like I said, if you just apply the ad guidelines and the guidelines that apply to individual guidelines that apply to realtors, you should be okay.
Jonathan, you have a question?
Yeah.
As we're seeing expansion of teams, and I feel that we're getting people from Westchester now that are coming into Rockland and vice versa, because you are doing real estate in Westchester, this whole trade thing about the timing of everything, in Rockland we have this, I feel like it's a boys club rule about this 30-day closing. If we have a closing date, it's always an on or about. And I've never really understood the clarity, because I thought it was 10 days legally where you can issue times of the essence. Is that standard practice in Westchester as well? Because I just like to set the proper expectation for agents that I'm dealing with.
Okay, this is a case. This is from case law. In New York, the leading case, and I don't have the citation, but the leading case is on time of the essence letters. And we all use on or about. Case law is interpreted on or about to mean a reasonable time. In most instances, a reasonable time is 30 days. If you look at the cases, has there been a judge or cases that have been decided less than 30 days or more than 30 days? Absolutely, right? Because it's a reasonable standard. So you're not going to know it, I'm not going to know it. But for the most part, we can say, you got about 30 days. Problem is the case that came out, there was an attorney that sent the time of the essence letter because he knew that the buyer was going to breach. So he sent the time of the essence letter prior to the date of the closing of the contract. The judge specifically said in that case, you can't send out a time of the essence letter if the date in the contract hasn't been passed. Even if you know that the person is going to breach contract, maybe lost a job, whatever the case may be, that case basically outlines what my requirements are and what I tell all my clients. And this you can almost say verbatim. The on or about date, if I closed an on or about date, and this is just, if I closed an on or about date in my career, and it's 20 years that I've been doing this, 5 or 6 times, right? Thousands of closings, it's a lot. If I have a Connecticut office in Connecticut, if the contract date is that, you're lucky if you don't close on it. And most of the time, 1 or 2 days will go by. And even there, you're hit with per diem penalties. Okay? Right. New York, the case laws come out, and this basically is, unless they change the law in Albany. So I can't send the time of the essence letter out until literally the day after the date of the contract. Do I do that? No. Normally, I'm not going to know in that situation. They kind of knew that they were going to breach. Most of the times, the bank's delaying, this guy's delaying, whatever it is, and they need a survey, something comes up. So I wait a little bit, and then I'm like, I'll be ready to close. If a couple of weeks goes by, okay, and then I see no movement, I usually call up the attorney and say, I'm going to send out a time of the essence letter. Just giving you a warning. Use it in any way that you need to. Just know I'm preserving my rights, because if I have to go to court, I need to have that on file. It's worth nothing at that point, because it's not gonna force them to move any faster if they're not gonna close. But I can't send it out before, and even in that letter, the court says I have to give them a reasonable time, which could mean another 30 days. My interpretation, if it's an all-cash deal and there's no financing, some courts allow 20 days to be reasonable. I, as a matter of law, of rule in my office, and most attorneys follow it, give 30 days in the notice, and say, you have to come to my office on such and such a date, 30 days from today. If you don't close, I'm keeping your down payment. That's it. Am I allowed to release the down payment? No. Like I said before, I have to hold it in escrow, parties have to fight it out. But that's usually the period of time. So in New York, it stinks. That's why I tell everybody, 30 days for mortgage commitment, 30 days to try to close, probably 90 days is the time frame you should tell every one of your clients. It doesn't help to tell them we're going to close in 45 days when you know there's mortgage contingency, they may need a survey, they're working on, selling another house. So that's the time frame I tell them. The law really doesn't give me much more than what I just told you, and I just follow it. I got a time of the essence letter back, from an attorney, and he put 15 days in there. And I called him up and I said, really, 15 days? He actually revised it and gave me 30. There's no law, the law doesn't say you have to give me 30, but I called him and I said, give me at least 30. I knew it was my client's fault. I said, give me at least 30. Ended up, they withdrew a commitment on my client, and we ended up getting another commitment and closed within 30 days, and only because, I called in favor from one of my mortgage brokers. So that's basically, that in a nutshell. So there's a lot of information on teams. Ed wrote an article in October about, what you need to do. It's all real in November, really. We all talked about teams at the NISAR conference. It's basically a good outline of what you can and can't do, and all it does is follow the reg, the section 175, 125 regs. And it tells you exactly what you can do, what you can't. And if there's any question, again, you're not going to be the one determining what happens. If there's an issue about teams and how they're being used, you have to go to Rosemary, or Rosemary has to basically make sure she takes, a look at it.
And we also have extensive information on teams and how we handle them in our P&G.
John?
Yeah.
Let's jump back just real quickly to teams. So a team hires somebody to do some clerical work, okay? Not licensed, okay? They're paid as an employee. They're doing a great job, okay? We start to add on additional employees, non-licensed. They start to speak on the phone, and now there are certain things they can say or not say as a non-licensed person on the phone. In order to protect ourselves as the agent and the team and broker Rosemary, we now say, you know what? It would really be in everybody's best interest if you become licensed. Now, project a year or two down the road, this person is great. We have a couple of other non-licensed employees.
Again, always get licensed under Rosemary.
I'm sorry?
As a licensed salesperson under Rosemary's brokerage license.
Right, but these people are employees that we haven't gotten them licensed yet.
If they become licensed,
Go
ahead.
Okay, we've developed medical insurance for them, internal profit sharing, our Keller Williams profit sharing. They're clearly by all IRS definitions employees. Now, because we want to promote them and protect ourselves against possible lawsuits, because they're talking on the phone, they now become licensed. The minute they become licensed, now we have to terminate them, make them a subcontractor paid by the broker, and risk being sued by that employee because now we have to take away their benefits because we can't provide them because they're not an employee. And they've had medical insurance?
Nothing doesn't matter. The DOS is very clear. The team does not function as a separate entity, so even what you're explaining, and I'm gonna be very clear with you guys, teams are basically 1, 2, maybe 3 people, right? That's, you know, the minute, and this is a test that really hasn't been focused on a lot, but I know that the DOS has a very strong opinion of it. The minute you start seeing like you're a separate entity, having your admin answering calls to you, which you should be doing on your own, the test is going to change, and you're going to be subject to losing a license, and Rosemary is going to be subject to licensing this. So you have to be very careful what you think this team is. And I try to explain to everybody, the team is really just a couple of, licensed personnel who operate under the main brokerage firm, okay, to, promote a team type of, atmosphere, a team logo, something like that. The problem is the more you become a separate entity, that's why I'm not saying you can't have an admin and pay. When you have a staff of 16 people and you're issuing W-2s and now you have profit sharing, listen, I'm telling you, keep it very simple. If you want to open up your own brokerage firm, you can get a brokerage license and open up your own firm. But the more you do what you're saying, and I'm being honest, the more you run the red light with the DOS and, losing licenses.
Right, well, it's a struggle in New York State, because we see this in Keller Williams, and we see teams in other states that have different laws, in a different situation. I think unfortunately, the key is in New York, you have to think ahead about how you're going to structure the team. And you need to think ahead, not only about the people that you hire, but how you are going to compensate them. And is it wise, before you maybe start some type of employee benefit program, you get them licensed first, so that you're not behind the 8 ball and taking something away from someone, but that you have a business plan and you're thinking about it, and you make them licensed, and maybe then at that point you're grossing them up for whatever benefits they're going to be able to buy. I mean, we have the same situation in many states. Keller Williams has a national plan for health benefits, okay, but because we're in New York State, we can't offer it to our people here. So,
It's tough. New York State law is New York State law, and I wish I was in other states that allow, more flexibility, but we're not. So I'm here not to tell you to push envelopes. I'm here to tell you to stay in the envelope. Keep it closed. The minute, and I can tell you, we deal with them with the DOS Live, and they give us a lot of internal information that normally would not be, provided to a lot of other attorneys or practitioners. And we get the feel, and I can tell you, they're not looking, they don't like W-2s, they don't like teams. It's being legislated because we're pushing it, because the Board of Realtors is pushing it, because it's a political, agenda. And the reason why it's gotten so far is really because of the Board of Realtors in New York. Because we're trying to help the team and the brokerage industry. So, like I said, that's a specific issue. You're running, on the fringes, and you got to pull it back. And if there's any issues, you have to engage counsel, and then you have to get them. I'm not here to give legal advice. This is just a seminar, but you have to get legal counsel to tell you what you can and can't do. And if you think you're pushing the envelope, the first person you should go see is Rosemary, your broker, because you're working for that broker. You're not working for yourself.
right, and we've said all along that as we grow our teams internally, we may have to change our policies, and we may have to seek counsel on how we handle certain things. So, we have, as a company, we have a very flexible attitude with respect to the teams there.
I can just say from this week alone, I had 2 buyers who basically said to me they spoke to a team and said our company and my buyers, because they just call anybody, turned around and said, oh, Keller Williams does this, how come you don't? So their perception of team, when it's an individual, and whoever they're speaking to, perceive whatever was said as you, Keller Williams. So that's why it's verbiage and agency.
And that's what it is. That's really a lot of the focus in the law, is that it's, your superior, respondeat superior. This is the brokerage firm. That's what the guidelines say you have to do. So if you're a team, you have to say, we're a team of, right? You can't stand on its own. You can't look like, if it smells like you're trying to, be your own thing and do your own thing, you're probably running the red light, So that's really the essence of it. Again, we're short on time. We only have half an hour, so we got a few sections left. But, if you need anything, there's the article on it that Ed wrote is really a nice step-by-step analysis of what you need. And obviously, it's not going to cover everything, but it does help out, in that kind of arena. But again, you guys are represented. You have a good support structure, so you don't do anything, without notifying, Rotary and compliance, officers. Just quickly, I'm just going to go through a couple of decisions. I got 15 or 20 of them that we went over, up at the NISAR conference. I'm only just going to point out a couple of them. In the matter of Troy, the complainant alleged that the Troy failed to provide proof of meeting its CE requirements. What's funny is here the ALJ found the complainant, DOS, who has the burden to prove, the charges by substantial evidence, failed to do so. The complainant failed to prove, one, that the respondent was ever asked to provide proof of completion of the education requirements, so the DOS never asked him for it. And two, the respondent made a material misstatement which needs to have been made with the intent to deceive. So those are the two elements of this case. Did he make it with an intent to, if there was a misstatement, okay, did he do it with the intent to deceive the Department of State, or, the DOS? The ALJ held that the insufficient evidence was presented by the complainant because there was no intent. They couldn't find, if it's to me, I would have, earlier on in the DOS decision, if this was a few years ago, I think it would have been fine. Nowadays, it seems like they're a little bit more favorable and trying to see, did he do it, did he just simply check off the wrong box when he put in his certification, or, was there an extenuating circumstance, which leads me into the next case. Here, in the matter of Kritikos, basically, they did the same thing. There was a material misstatement. They found that she was guilty, okay? But she said, I'm having health issues. I think she was caring for, an ill dad. She was going through financial hardship. So here they did say, there was a material misstatement. There was an intent, to deceive. They found that she did try to, deceive the department, but because she didn't because there were extenuating circumstances, they didn't hit her as hard as they would have. They just did a fine, said, take additional CE requirements, and basically settled it that way. So these just show the two different approaches in pretty similar circumstances on how the DOS tries to figure out what to determine on whether there was a material misstatement. Bottom line, just make sure you take the CE 22.5 courses. I'm sure everyone in this room, because
Well, we require you, when you renew your license, to send us proof of your CE. That has to go to Diane Carroll in New City or to Erin in Middletown. And we're expecting that if you're checking that box that you've taken your CE, when you do your renewal online, that you have actually taken it.
Yeah. Do you actually require them to give you copies?
Yes, we do.
Good. Most brokerage firms don't. So you got to make sure you're good, because if you cut it off now, you're not going to be at the point where they say, give me the CE, and it's not done, check the boxes and check off. So you're covered. I put the decisions in the tables as well.
We've had people who have not done it and have been active agents who have been unable to pursue their livelihood for a certain period of time because they could not get their license renewed.
It's a hefty, this is your livelihood. Same thing, the attorneys have to, submit same certification, we have to have, you know, our CLE, legal education, and if we don't, a lot of times it won't come up now, it comes up when you're audited or two, if there's agreements, you know, or complaint. So, you know, there's the DOS decision regarding realtors conducting unlicensed activities. Here, the salesperson, the respondent was previously licensed as a real estate salesperson. A few years later, however, knowing that the respondent's license had expired, she posted various advertisements on the internet in which she offered apartments. This is really simple, you know. She's actually, you know, offering real estate license services to the public, and she's no longer a licensee. Here, she tried to put the blame on the broker firm, saying, I didn't advertise it. You know, the broker advertised me, you know, put these advertisements for this apartment and that apartment. And the DOS, ALJ found that, you know, one, she did get paid $600 for closing one of the rentals. So that payment alone was already, you know, and the broker didn't pay to her, the client paid it to her directly. So, you know, obviously, these are just easy ones, but you gotta make sure. Some of the cases, there's brokers and agents out there that don't even know their license is expired. They just keep working and they forgot to send in the renewal.
Yeah, I want to bring up something on that. I think John Paul mentioned it before, that we do have a lot of brokers from outside of our area now who can come in and show our properties. Our MLS does allow for a day code. My recommendation on day codes, and I think it was Bill Irwin brought this up, as a brokerage, whether we're going to allow it, because that, again, that's an increased risk for us, okay? If a broker from out of the area is coming in to show your property and it's our listing, I would not give them a day code. I would make sure that you are there for the showing. There's a couple of reasons. Number one, what I just said, the increased risk that we don't want. Number two is they probably don't know the area that well. And there's probably information that you need to be there to give to the potential buyer that they couldn't give. So that's how I would handle it. And the other thing is, before you go out with that broker, they need to send you a copy of their license to make sure that they're licensed. Because we have had people who have contacted us, even within my own team, wanting to show properties that turned out not to be licensees.
Again, I can tell you, KWHVR and some other brokerage firms do send, when they send me the information to prepare a contract, they actually have this license attached to the listing, you know, the memo of sale, the listing. I mean, some offices do send me that information, but they probably have it all in their file and say, here, you know, John, here's everything. And I see it sometimes attached as an attachment, you know, just as an aside. So again, the one thing on this case, which even though it's pretty simple, if she would have offered any proof at the hearing, okay, she didn't really provide any proof that the broker had posted, you know, the advertisements for the apartment. You know, but then the broker would have been fined or brought in as well. There was just no proof. So one thing that I can tell you is a lot of times, what happens is a lot of these salespersons, they're not represented by attorneys. They'll get a complaint, and then they'll try to respond themselves. And then if, you know, they go to a hearing, they'll go, you know, without an attorney representing them. And if you try to overturn any of this in an Article 78, which is the only way you can overturn an ALJ's decision, the court, you can apply for an Article 78 to bring their decision and get it reviewed by a judge. The only way the judge is going to review it is if it can look back and see if there's a due process, you know, error that was, you know, and if the facts of the case show something substantial. So if you don't substantiate your arguments, you're going to probably end up losing, you know, like the matter of an argument.
John, are you going to cover under unlicensed activity finder's fees, or is that separate?
The finder's fees are at the end.
Okay.
Yeah, I can do it now if you want. Yeah. All right. Finder's fees. So finder's fees are not permitted to be paid at all. And this is just a blanket statement. You know, you can try to argue with me and figure out how and way, and, you know, which way. But it really, we get this question a lot. And we've gone over it, you know, to death when we've gone up to the legal conferences. But basically, finder's fees are not permitted to be paid to any person who is not a licensee, licensed under the Department of State, under the real property law. The case law is very clear. If there's a real estate involved, then no person can be paid a commission. So there are certain cases where a majority of the transaction, and these are really big cases. I mean, you know, the ones that I was able to, you know, look at, it's really involves a business transaction, not a real estate transaction. So, you know, you bring, you know, two parties together. There's a finder, you know, a broker, not under the real property law, but a, you know, broker or a finder that basically brought two parties together to negotiate a business transaction, a sale of a business. The courts have held if any part of that transaction involves real estate, that person can't pay, can't get paid a finder's fee. So, you know, but the judge also said it depends on the amount and what the, you know, if the real profit, if it's a $20 million deal and the real property element is a $300,000 vacant lot, obviously the finder's fee, the law will probably find on the side of that person who is the finder's fee because that has nothing to do with the real property. It's very insignificant. Vice versa, you know, you bring the party together and, you know, even if it's a little bit over insignificant, the judge, you know, and get paid, you could, one, lose the commission altogether, and two. So, you know, there's ways you could probably structure the transaction. All I would say to you is don't even get involved with that. But if it involves real estate at all, the law is very specific. Unless you're licensed under the real property law, you don't get a commission.
Yeah, so I think the easiest rule of thumb for us to use on this is if somebody is not licensed and they're not a buyer or seller in the transaction, okay, they can't get any money out of it, okay? They can't get any money back from you or anything like that. Now, we do participate in things like Homes for Heroes. You know that there are other brokerages out there like Redfin that give something back to the buyer or seller as part of the transaction that used to show up on the HUD, now it shows up on the CD, okay, that is a reduction in commission, okay, that is okay. That is okay. A reduction in commission back to the buyer or seller, as long as it's shown on the closing statement, parties in the transaction, is fine. Somebody had come to me once and they wanted to give something back to a seller because they subsequently bought with them, but they didn't do it within the transactions. And I said, no, we can't do it. So that's really the rule of thumb. You know, if you're going to make a concession, you can do it, but it's got to be shown on the closing statement. Okay? Excuse me, what? Right, right. And so you're reducing the commission to the seller, and the seller's then showing it as a credit to the buyer. That's the real trail of it on the closing statement.
Yeah, that's how we handle it. The brokers will call us and say, John, we want to do it in the contract or whatever. You know, we could either work it out ahead of time or work it out prior to the closing, but it gets worked out. And that's a credit. As long as the parties related to the transaction, whether the seller and the brokers, that's fine.
But somebody gives you a referral, and they're not licensed, and they want money for that referral, it is not okay.
You give them again?
Rosemary and John?
No gift. No, not even dinner, not even a ticket to the Yankee game. I'm not kidding. I mean, I've seen people lose their license because they got tickets to a Yankee game.
Yes, Peter.
Yeah, I believe I know the answer to this, but I want to be clear because I know there's been debate time and again over this. If I, as a licensed agent, help someone on a market center or maybe Keller Williams in Westchester, wherever, and they are just grateful, and they send me a check for $100, even though I'm licensed, I believe I cannot take that check. I believe everything has to come through Rosemary. Is that correct?
Yeah, no, it can't come to you directly. But you can certainly, fee split between agents, but it has to go through the broker. You can't be a direct payment. Absolutely.
Thank you for the clarification.
Any of the closing, they're all payments to the broker. We don't have a lot of time, and I'll take it after. I just want to get it.
Anthony, any quick question?
Can we get a monetary donation to a charity?
I don't see why that would be an issue. Yeah.
So, I think actually Anthony and I were discussing this last week. So if an agent got a commission, okay, and an agent themselves personally then wanted to donate to a church, and they wanted to donate in somebody's name,
I don't see.
it's outside, as far as I'm concerned,
For me,
it's outside of us.
yeah, it's outside. Once you're done, and you want to do something like that, I feel our press at the DOS. I mean, I can see an investigator saying something, but I'm not going to say yes or no because I haven't seen the fact pattern and the law doesn't, so I'm safe to say I think you're okay with it because there's no law that's on the books and I haven't seen DOS decisions and we've seen thousands of them, where I've seen that fact pattern. The next thing is I want to just touch upon what commissions do, because obviously this is, an important thing. You want to know, the if, as, and when rule and all of that. It's fairly recent, 2011 in the legal field is very recent. As you can see, we had 1976 law adopted and held as being still, the law of New York State. So here, Bowery Partners versus EG West 37 involved the seller who included in the listing agreement the common New York language, the commission shall be due and payable only if, as, and when title taxes. So those are the trigger words. That's a lot of times, if you don't have that in there, I can tell you that normally when you have the lawsuit.
That's an M3 exclusion on the MLS form. We all should be using that exclusion on every one of our listings. That's M3.
Okay, and the thing I can tell you is a lot of times when the listing agreement goes to court, it's because the limiting language is not there, and then you have to fight as to when the ready, willing, and able purchaser, and you have to get the facts and circumstances of each case. So here you have the common language. After receiving an offer, the seller demanded that the contract of sale contain no conditions, meaning that all due diligence by the buyer would have to be performed before the contract was executed. The buyer procured a broker that was willing to pay full listing price, $21 million, but would not agree to the no condition demand. Subsequent negotiations broke down, no contract of sale was signed, and the seller refused to pay the broker's commission. Always use the written listing agreement. Okay, that's one of the main points that are brought out in this case. The New York Supreme Court upheld the seller's position. Basically, the law, it's just to confirm the law. If you have this specific language, if the title doesn't pass, the commission does not come, is not due. What we should include as real estate agents is also except for a willful default on the part of the seller. Okay, so that will save you a little bit. If you have that language after the if, as, and when language, and you see that there's intent to, kill a deal, and there's a breach by the seller, there are cases that will hold if you have that willful language in there. But then there's other cases that say that New York law really is New York law. You have the if, as, and when, unless for egregious, real, clear breach and bad faith on the part of the seller. Most courts in New York are not going to hold, that there's a ready, willing, and able, condition to the transaction. Parties should expressly state whether a commission is earned if no closing occurs, because the seller declines to accept a full price offer that conforms to the first terms of the listing. if a commission will be owed on these facts, a careful seller will set a high enough listing price as not to be dissatisfied with the price offer. So these are all the, little bit of the, rationale that the court took in deciding this case. If the seller expects to impose unusual terms or conditions in the contract of sale, which might raise the question of whether the seller is acting in good faith, again, that will default. The broker and seller are well advised to expressly agree in the brokerage agreement that those terms will be part of the contract of sale. So basically, that's really, the extent of that case. New York law is very well settled. There are states that are very broker friendly. So if you have, if you don't have the language, okay, New York leans to the broker. In other states, it goes the other way. If title doesn't close, I mean, it's really just diametrically 180-degree opposite. New York protects the broker. Other states, there's, the law is, if it doesn't close, they don't get a commission, regardless if it's regular or legal, status.
Just regarding any difficulties that you might have with commissions, if you in any way think that you are not going to be paid a commission, or that we will have a problem collecting a commission, the earlier you come to us, the better, okay? The worst thing that happens is when it's on the day of the closing, and somebody comes to me and says, this is a problem, and this has happened. Or actually this year we had one, it actually did close, I guess the sheriff had to come, it was a crazy deal. It was like 2 years later, and the sheriff finally got the seller out of the house. It was a super specific performance, and we were able to get a commission. So the earlier you come, the better, because one of the things that John said before that's really important is that New York may be a broker, we may be saying it's in favor of the brokers, but it's very hard for us to collect the commission because there is no lien law, okay? Now, there's this escrow thing that they have to go to the courthouse. We don't use that, okay? Our legal counsel has advised us, in most cases, what we will do is we will send a letter to the seller's attorney saying we are making a claim on the escrow. And you heard what John said before. Once we make a claim on that escrow, they can't release that escrow. Okay? So now, if we do that, and we have enough time to do that before the closing, we are in a much better position. Once that closes and the escrow's gone, we have to litigate. And let me tell you something. I've only litigated once in 20 years. And it was because it was a $50,000, almost a $50,000 commission that was at stake. So it paid for us to litigate. But by the time we finished paying the attorney over $10,000, and the judge is going to make you settle no matter what, because that's what judges in at least Rockland County, that was our experience, do. We ended up with half the commission, less the legal fee. Okay, now, so if it's a normal $10,000 commission, it's not worth it. So we're really out. So the earlier you can come to us with any potential problems, the better off we'll be.
Yeah, you want to preserve your rights. You want to make sure, and you'll get an inkling if there's an issue, ahead of time. The thing with the commission escrow, the commission legislation that was passed, nobody uses it. It really, and not to say, I mean, we've sent letters to sellers' attorneys and they just disregard the letter. They'll pay out the money at the closing, and then what I see is that the next thing is when the lawsuit is initiated, that attorney is also named in the lawsuit, as reaching fiduciary responsibility. The problem is sometimes the judges, and what I've seen is the judges, if the seller does release down payment, the parties to the contract are the only parties that escrow agent, sometimes the court will say, well, he had no duty to the seller broker or no duty to hold the money other than, well, what would happen in that situation is sometimes you would, and I would suggest we would get in the phone with the buyer's broker or the seller's, the buyer's attorney, and have him also send out a letter as well, so that we can basically preserve the right, so that if the judge does decide, that I don't have, legal status to send a letter But he's on notice, they're in the contract. I'm comfortable most of the time just sending the letter, and most of the times the attorneys are not going to release the down payment. Unfortunately, I know, because I have an attorney who I'm very close with, who actually came into my office and told me, John, if you sent a letter, we release the down payment. So, and they need that attorney. So it happens most of the time. We're protected that way. The other way with, filing the commission, that it's just one big item, and I'm not going to go into it because it's a whole another course. But one big item is that you actually reduce your statute of limitations to collect the commission when you use that route. So the normal route to sue is a 6-year statute of limitation. If you use the commission escrow, the commission act for realtors, you can reduce that almost to like 6 months. So if you don't act within the 6 months, you actually lose your right to, enforce your rights. So we don't really recommend it.
I would disagree that New York is a broker favorable.
The case law, if you leave the language out and you can prove it, you can win. I mean, most of the cases is when you leave out the if, as, and when. If you have the if, as, and when in there, every case comes down in favor of the seller. Because it really it's clear. It's if, as, and when title passes, If we add in the except and willful default, you have a shot. But the law itself really is not favorable to the seller. And like I said, it's not part of this course, but if you look at the real estate in-depth article that I wrote, it really shows you how important the listing agreement is and how important you need to know up front whether a commission is earned or not. Because those 3 cases that I highlighted in the next month's article really give you a good idea when you're going to earn a commission and when a judge is going to say, yeah, that commission was earned. In one of the cases that I have, that I referenced there, it was a father and son. The son didn't give the father the authority to sell the house. All of the facts in that case pointed to the father having a verbal agreement, even though the broker tried to get the father to sign a listing agreement for the property. Never advised the broker that there was that his son also owned the property. What's fun in that case is that the case actually, the fact that the law actually says that the broker is not responsible for trying to determine who the owners of the property are. There's no law in the books of New York that require a broker to find out whether he's represented. So the father who came to this broker said, I represent, I'm the owner. I have total, he didn't even know that the son existed, and the father kind of lied and said that he had a power of attorney for the son. He didn't have that either. So what happened was the court found that the broker was entitled to a commission. It was a verbal agreement, and usually it's because there's a verbal agreement, where there's enough facts where they can prove it, determined that the father owed the commission to the brokerage firm in that case. And it's an older case, and then I can bring it up to you with more newer cases. But it's important to know that the law is still the law. If they can prove a listing agreement and you bought a regular and able purchaser, that case goes to the next step. They sign contracts. The father signed on behalf of the son. 2 weeks later, when the attorney found out, I don't know how the attorney didn't know the son was involved. No, he misrepresented to the attorney that there was a power of attorney. 2 weeks later, they canceled the contract. I don't know how the buyer's attorney didn't keep the down payment, but in the facts of the case, they canceled it, and they returned the down payment, and the buyer was okay with it. Basically, on the attorney's rep, the son owned it, he didn't sign it, so we probably called him and said, we need to fill this because we can't go forward. And there the court held the seller did so much to push this to a deal that even though the contract was legally canceled between the 2 parties, the father still owed the commission. So,
even though there may not be a law for us to find out who owns the property, okay? We don't want to have to litigate to get a commission or something like that. So we do tell you, you need to be researching and making sure that whoever you're having sign a listing agreement are the actual owners of the property. Same thing with multifamily, you need to be providing a CO, even on rentals, that the property is legal to be rented, or if it's a multifamily, that there is a CO that exists. The tax record is not good enough, okay? Many tax records say multifamily, and there is no, they may be using it, the tax assessor may have it, but there is no CO on that property, and it's not gonna be able to transfer title. So we gotta do that CYA on these types of things and make sure that we have the right parties and the right number of units to property.
Yeah, if you look at my October article, basically my 3 rules of thumb, okay? Every broker should ask for at least, the very least, a deed, prior title report or title policy, and a survey. I mean, those are really, you know, you'll read the article and it goes into, but those are important. You know, one, because, like Rosemary said, tax bills sometimes don't reflect all the owners. There could be 4 owners and it only reflects 2 of them. You know, so you can't go by that. An actual deed, you know who the parties are, and you have to make sure you deal with the right parties. The other 2 cases that I deal with in the next month's article is basically divorce couples, okay? Where the courts really, if there's an agreement and there's a divorce couple, you know, a divorce situation involved, you need to get the agreement of both parties when the house is listed. You have to make sure you're up front. Sometimes one broker, you know, one party wants to go with one broker, another party wants to go with another, and sometimes you got to go to court and have the court decide who they're going to use.
So the divorces are the messiest things. I get more of those across my desk than anything in a year. The other thing you want to check on divorces is if you have something, get something in writing ahead of time that says what is going to happen if one party ultimately buys the other one out. Okay, because right now we're in a little squabble because one party decided to buy the other one out, and we had brought a ready, willing, able buyer for the same amount of money, and now, you know, we're looking for a commission, and they don't want to pay a commission because it's an internal transaction. So, yeah, divorces are messy.
So you just gotta be, you know, and really, if you take in clients and you don't know what to do with them, you have a wonderful support staff. So you have to talk it through and figure out if someone else in the, you know, in the firm has dealt with this and how to go about it. But you have to be very clear. Because a lot of times, you know, a husband or a wife will, you know, engage a firm and not say anything about it. Sprinkler systems, just to tell you that this was defeated. This was a huge, huge victory for us. It would have cost basically $24,000 for a 15,000 square foot home if this would have passed. So basically, you know, we have to thank NYSTAR and the Hudson Gateway, you know, for going up there and lobbying and pushing, the Builders Association, absolutely. So, you know, and listen, we're not trying, the point to take away on this is that we're not trying to say it's not a safety issue. It's just more of a burden issue than anything else. We, you know, obviously the arguments were, you know, they brought family members, especially lately, you know, in the past few months, we've had a lot of fires with, you know, gas explosions in the city and stuff like that. So it wasn't an issue that wasn't really an important issue. It was just to tell the client $24,000 is a lot. I'm just going to go quickly in 3 minutes and finish the rest. Legislative, hold on. Source of income is law in New York State. It's not law in New York State yet. It's there. It's going to happen. We're just waiting for the bill to be passed. It just becomes an additional protected class. The materials, I have the actual law and it outlines. If you look at the bold, underlined language that's in there, it shows you the changes that were put into the law this year that are trying to, what they're trying to put into the bill. It's going to pass. Westchester already has it. New York City has it. Suffolk County already has it. So you can have, it's a discrimination factor, okay? You can't ask for source of income in order to make a transaction.
Just to make it real simple, it basically means that once this passes, landlords will not be able to exclude Section 8 tenants. So
That's why the law came out. The unfortunate thing is now it applies to everybody. So you can't discriminate even if it had nothing to do with Section 8. It's really just a blanket. You know, I had a broker come up to me the other day when I did a presentation and they asked, John, does this mean I can't ask them where they make their money on the initial application? No, you cannot. You can, it can't be one of the questions you ask them. You can ask them the amount they make, but you can't ask them where they make it from. So, yes, because a lot of what the focus of the law was for Section 8, they thought that they were being discriminated against because they were making, you know, governmental income rather than, you know, income on a private level. We're going to take, and let me just finish up because we're just, we have about 6 seconds left. Hold on. Yeah, well, that's allowed. Exactly. Just an important update to the tax extenders that was signed in December.
Yeah, this is important, guys.
Okay, I'm just going to highlight the deduction from mortgage insurance premiums, which extended to the end of this year. The phantom income on short sale, okay, was actually not allowed anymore. So there was a short sale, and they forgave $50,000 or $100,000 in debt. Your clients would have to show that as income and pay taxes on it. They extended it to the end of this year, so that's a good thing. And there's some other energy tax credits that they extended to the end of this year. All right.
You can't ask where it came from. When we change it over, the applications will just have an amount for the income. It won't say where you can we ask them if they are employed?
Yes, you can. Once you accept them and you say they're going to, you know, then at that point it doesn't stop you from getting credit reports. Okay, the law specifically says you're still allowed to get credit reports and all of that stuff.
You can ask them if they're employed. Yes. You can ask them the amount of income that they get, monthly income per month. So they don't have to break it down. This month is from our employer. This month is from Section 8. It's just an amount of income.
I mean, it's pretty simple. Obviously, same standard for the client.
Okay. I'm going to go down the line here. What's the question?
No. Source of income, if we ask.
Okay, let me ask you a question. Why would you be asking for pay stubs? That should be the landlord. The landlord, we're out of it.
Yeah.
We're out of it. We're giving them an application. The landlord will do their verification.
Yeah, it's the broker's application. You know, the landlord, he's got different, you know,
I know at some point we were going to hit the high.
Oh, yeah. Listen, source of income is going to be.
You know what? Let's not go through this. It's not
It's
law.
not law yet, right now. Okay. The legislation is in here. When it becomes law, we'll let you know, and then we'll send out a memo. But basically, all you have to know is that it's now another protected class. So forget about all these questions. Would you ask for any of the information on the protected class that's there now? No. So you would just get rid of, if it says any source means where is it coming from, right? That's it. If you ask, if that question is on the thing, you just say it off. That makes it easy, but we'll clarify once it becomes law. If you hand it and push it off to the other side, you may have liability. You gotta just be careful. You know, anything that you give out, anything you give out, you gotta really, and they exclude landlords, but only for, I think up to 3 or 5 families, something like that as well. It's in the legislation, but it's not law yet, so we don't have to worry about it in Rockland. Westchester we do, but it's been out there for a while already. They don't know. you know, as soon as it comes through. This year, it could be 3 months, it could be 6 months, but it's there, and I don't think it's gonna be changed. Do you want to do the door knocking or something like that real quick?
Yes. Okay, we come up with last important topic about door knocking, okay, so we're just gonna.
All right, this is a quick, there's nothing in the real property law that governs whether you can door knock or not door knock, whether it's a good policy or bad policy. You have to go with local ordinances. I printed out a handout from Robert Estorino's office from Westchester County that tells you, you know, what your rights are. It's all governed by the peddling and soliciting laws under every municipality. In your pamphlet here, in your report materials, I actually just printed out Piedmont because I knew we were in this area. And it's really, if you look at all, I mean, I went through all of the, you know, all of the localities. One way or another, the same definition applies to soliciting, and if you're a solicitor and you fall under that definition, you have to get a license. The law does require that if you're working as an agent, or not a real estate agent, but an agent or an employee of another company, that company has to apply for a license on behalf of the people who are going out. So, you know, it really is something that's just a legal requirement, and it's an internal, you know, procedure on whether or not it's, you know, promoted or not, you know, internally.
Yeah, we do allow door knocking, but again, so now we're clear that you need to check the local law first, and if you need to be licensed in order to door knock in a specific area, or if they have a prohibition on door knocking, then you can't do it. So you have to either get the license or and check the local law first.
Yeah, I'll give you a quick definition. Any person, principal, or agent engaging in door-to-door solicitation at home, businesses, or in any public place or street, or from any premises not an established place of business, or order for sale of goods, wares, commodities, or other merchandise, including books or periodicals, or the performance of future services, or for the making, manufacturing, repairing of any article, thing whatsoever for future delivery. That's the definition of a solicitor. If you fit in there, you need to be legally licensed, and you gotta go to the town, fill out the application under the brokerage firm, and then the person who's going door to door, probably the you know, paperwork that needs to be filled out, who's allowed to go on behalf of the company.
There's just two quick things I want to say. Number one, when your customer or client asks you for information, like about lead paint or about different things, schools, okay, remember our saying, be the source of the source, but not the source, okay? So refer them in the right direction, but you're not giving them a direct answer on it, okay? That should be our policy to cover. Next week in New City on Tuesday, if you want to direct deposit your commission checks, you will be there for that. That's the team meeting on Tuesday. They already have it over in Middletown, and I'm sure they're all working that, so that's how it's good. And on the 26th, we have the Hudson Valley United Awards Breakfast at West Hills. And on the 28th, we have the Hudson Valley Awards Breakfast at the Hilton in Pearl River. So I want to thank John for coming today. I know you spent a lot of time putting all this material together, and we do appreciate it. And we hope we don't have to talk to you too much. And again, thank you all for your time.